A very good day to Dr. Hema and those present. Today, my teammates and I will be giving a presentation on statutory interpretation. First and foremost, I'd like to give a brief introduction on the members of my team. Starting with me, Choi Hui Yi, Ong Ching Yun, Bernice Hyong Ying Shen, Chan Yun Zi, Shanice Chia Yi Ning, Carol Tan Ying Shen, as well as Ali Cheong Wen Fei.
What is a statutory interpretation? Lord Diplock mentioned that statutory interpretation is the process by which the court ascertain and give effect to the intention and of Parliament as expressed in legislation. In a nutshell, statutory interpretation is the process of determining the meaning of a law in a specific case. Laws may seem straightforward, but often their application is not as clear-cut. Thus, the role of the judge is to interpret statute as to make sure it is applied properly, especially when its language leaves room for uncertainty and confusion. To begin with, we will begin by looking at different approaches judges use to interpret statutes. The approaches are literal rule, golden rule, mischief rule, purposive approach, internal and external acts, and Hansard. The first approach is literal rule, and now I will hand over to Bernice, who will explain how this rule works, its advantages, limitations, and some key cases that illustrate its application.
So, I will begin with the literal rule, which is the most common rule in the English legal system. Under the rule, the judges will give plain, ordinary, and literal meaning of words, even if the result is not very sensible. This is because the main purpose of the rule is to discover the intentions of Parliament, as expressed in the words used. As Lord Ashe stated in Orange Judge of the City of London Court, if the words are clear, they must be followed even though they lead to a manifest absurdity. I will illustrate by using Vitali and Chappell. The defendant here impersonated a dead person who was still on the water list. Under Section 3 of the Personations of Waters Act 1858, it is an offense to impersonate any person entitled to votes. The court held that a dead person was not entitled to vote, so the defendant was not guilty. This shows that how the court apply the law strictly to the literal meaning of the words, even though the outcome seems unreasonable. Another example is Carter and Eagle Star Insurance Company. The claimant here parked his car in a private car park and was injured by another vehicle while walking away to his destinations. However, the insurance only covered the use of motor vehicle on any highway or other route to which the public has access. The court ruled that a car park is not a route, since it is used for parking while the routes are usually used to travel. So, the claim failed. Similarly, in Fisher and Bell, a shopkeeper displayed a fruit knife in his shop window. The statute said that prohibited offering for sale certain offensive weapons. So the court here held that merely displaying an item was an invitation to trade, but not an offer. So the defendant here was again not guilty. Again, the court followed the strict wording of the law rather than its purpose. I will move on to the advantages of the literal rule. Firstly, it promotes consistency. Since courts interpret the statute exactly as written, ensure that similar cases are always treated alike, respect parliamentary supremacy, because judges apply the law made by the elected legislature rather than imposing their own ideas. Moreover, it increases transparency, which helps a lawyer to give a clearer advice to their clients. However, there are some disadvantages too. Sometimes the wording can have more than one meaning, which may lead to unfair results that do not reflect the Parliament's true intentions. This lack of flexibility also makes it harder for the law to always keep up with the modern society, as stated in London and North Eastern Railway and Birmingham. A railway worker was killed while oiling tracks, but compensation was only for workers repairing or relaying tracks. since oiling was considered as maintenance. His wife could not claim any damages from the company. Watson argues that literalism relies too heavily on asset wording and always ignores the real situations. By the way, the judges will usually give the chance to choose the most suitable meaning from several possible ones, which usually hides the judicial discretions. Hence, although the literal rule always seems fair and objective, in reality it however often lacks transparency.
Thank you, my friend Bernice, for sharing about the literal rule. Next, I would like to share about the golden rule. Golden rule is generally recognized as an extension for the literal rule. It is being used when applying literal rules will lead to an absurd result. This is because the original meaning of specific words are too ambiguous. To avoid reaching a confusing conclusion, the court will try to reject the literal approach and provide a secondary meaning to the word that could result in a common sense interpretation. As per Lord Blackburn, the use of the golden rule involved the judges in finding what they consider the statute should have said or provided, rather than what it actually did say or provided. This means that the court could not just cast off literal rule for golden rule. The judges have to interpret and modify the literal meaning to what seems reasonable. Golden rules are said to be useful when there is ambiguity in the word, which the ordinary sense of the word would lead to inconsistency and absurdity. Besides that, when the word is capable of bearing a secondary meaning. However, we need to take note that there are no specific guidelines to when the court shall reject the original meaning of a word and adopt this approach. It depends on the court judgment on whether the literal meaning would lead to something absurd. The narrow meaning is to use when the meaning of a word is too ambiguous or bearing more than one meaning. The court will use golden rule to choose the interpretation that makes sense and avoid a result that would be absurd, unfair, or clearly not intended by the lawmakers. The law is given a reasonable meaning without strictly following the literal words. This can be seen in the case of Elder and George. The court held that he was guilty because being inside a prohibited place also counts as individuality. The wider meaning is to use when there is only one possible meaning to the word, but applying that meaning would result in inconsistency or uncertainty. This can be seen in the case of Re-Sigworth. The case of R and Allen, which is a landmark case, the Section 57 of the Offences Against the Person Act says that whoever is being married during the life of a former husband or wife is guilty. The issue here is, does married means a legally recognized marriage or just going through a ceremony? The court decided that married means going through a ceremony regardless of whether it is formal or not. Now, let's talk about the advantages of the golden rule. First, prevent uncertain or unfair result. By allowing judges to avoid literal interpretations, the golden rule ensures that the law is applied fairly and reasonably in every case. Secondly, when the law is applied in a sensible way, avoiding unfair outcomes, the public sees the legal system as trustworthy and rational. Thirdly, flexibility. The law can deal with unexpected situations without being strictly bound by literal wording. Followed by the disadvantages of golden rule. First, subjectivity, as interpretations may vary based on personal views. Uncertainty. This is related to what I have mentioned earlier. There are no fixed rules on when to apply the golden rule, which can lead to inconsistent decisions. Last but not least, limited scope. It only applies when the words are too ambiguous or could lead to absurd results. So, it cannot fix all unfair situations. And that's all for the golden rule.
Thank you, Yunzi, for your explanation of the golden rule. Now, I'll be explaining about the mischief rule. The mischief rule is a radical approach that disregards the actual words used if it leads to absurdity, and instead concentrates on finding the Parliament's intention when passing the Act. This rule was first adopted in Hayden's case. In explaining the mischief rule, I will refer to three key cases: Hayden's case, Smith and Hughes, and Elliott and Gray. In this case, it involved a dispute between Hayden and the owners of Ottery College over land following the Suppression of Religious Houses Act 1535, and as a result, the courts established the mischief rule in statutory interpretation. According to this rule, there are four elements to be discovered and considered when interpreting statutes. Firstly, what was the common law before the making of the Act? Secondly, what was the mischief and defect for which the common law did not provide? Thirdly, what remedy the Parliament hath resolved and appointed to cure the disease of the Commonwealth? Lastly, the true reason of the remedy. Moreover, the mischief rule was applied in the case of Smith and Hughes, whereby the defendant was charged with soliciting in a street or a public place for the purposes of prostitution contrary to Street Offences Act 1959. However, they were soliciting from upstairs window. They argued that they were not guilty under the said section as they were not literally in a street or public place. Nevertheless, the court held that they were guilty, with Lord Parker saying, "For my part, I approach the matter by considering what is the mischief aimed by this act. Everyone knows that this was an act to clean up the streets, to enable people to walk along the streets without being molested or solicited by common prostitutes. Viewed in this way, it can matter little whether the prostitute is soliciting while in the street, or is standing in the doorway, or at a balcony, or at a window, or whether the window is shut or open or half open." Subsequently, in Elliott and Gray, the defendant's uninsured car was parked on the road, jacked up and had its battery removed. The defendant was charged with an offence under the Road Traffic Act 1930 for using an uninsured vehicle on the road. Although he argued that he was not using the car, the court found the defendant guilty. This is because the court concluded that the intention of the statute was to ensure people who suffered damage due to road hazards could claim compensation. Thus, the word "use" was interpreted to include vehicles kept on the road as well. Moving on to the advantages of the mischief rule. This rule allows the court to uphold Parliament's intention by ensuring it is construed in accordance with the purpose of the legislation, thereby promoting parliamentary supremacy. Additionally, it may lead to fairer results compared to the literal rule, which would cause unjust outcomes. Not only that, it offers flexibility, allowing judges to use their own judgment and adapt the law to meet the needs of social and economic changes. This can be seen in the case of Royal College of Nursing and Department of Health and Social Security, where the courts acknowledged the evolving social circumstances towards abortion and recognized the expanded role of nurses in modern medical practice. On the flip side, however, the flexibility of the mischief rule leads to uncertainty too, as it allows inconsistent interpretations across various cases. This may be attributed to judicial bias, as judges are open to their own subjective evaluation while disregarding objective legal reasoning. Moreover, this rule risks infringing the separation of powers, since it enables the judiciary to make laws by exercising legislative powers. Considering that this rule was established in 1584, it is often viewed as outdated, particularly when in contrast to the more modern purposive approach. Lastly, it remains difficult to determine the Parliament's true intention when interpreting an act. I'll now hand over to my friend Carol, who will be discussing the purposive approach.
Thank you, Shanice, for explaining the mischief rule. I would like to introduce about the purposive approach. This is a method which is applied by judges in order to interpret the law and examine the intention of Parliament, instead of just focusing on the literal meaning of the law as contained in the statute. This method emphasizes the spirit of the law rather than the letter of the law, meaning that judges are looking at the objective of the law. As law dining stated in Margot and State Mellon and Newport Corporation, judges were there to determine what Parliament have intended by enacting the Act, by filling in the gaps and reconstructing the same. The European Court of Justice also takes this approach when interpreting European law, and it has significantly influenced modern UK statutory interpretation. The example of the purposely approved in action is the case of piston and freeman. In this instance, the female warehouse workers say that they were receiving lower salary than their male tracker, although they're doing the same value job. And the company defended itself by claiming that there were already a man who did the same job as the female worker, and he was paid the same amount, and hence the woman could not file a complaint. The issue is that could that claim equal pay for work of equal value? The House of Law say yes, because they told that the law was to provide equality in salary between men and women. Thus, the court concluded that the women could proceed to make their claim, since the intention of the law was to be fair and treat them equally. Furthermore, I would like to introduce about the diversity of Highland trustee and connotations, and which about a female worker who stated that she would pay less than she would have been paid if she were a man performing the same job. At the time, the company did not have other male workers who were doing the same job to use as a comparator. Therefore, she relied on her male successor, who replaced her later as a national comparator for her equal pay claim, and the employer appeal tribunal considered the claim to be viable by the use of a male successor as a valid comparator. The court found that his contract was cost and nice in type and nature to her, making him a suitable basis for comparisons. So the tribunal had jurisdiction to hear her complaints even without a current or past male colleague doing the same job. The other case is there are an Registrar General as Pat Smith. Here, Smith was a man who committed a murder and was detained in a psychiatric hospital. In accordance with the Adoption Act, he requires her birth certificate so he could file his natural mother, and the Registrar General refused to release it because the medical report suggests that he was mentally unstable and might harm his mother if he filed her. And the court decided that the Registrar General was right to refuse to provide the birth certificate to him. Although the Act said the document shall be given, the court interpreted it purposefully, meaning Parliament did not intend the law to require an act that could cause harm. Now, I would like to share about the benefit of purposely approved. Firstly, it can enhance the fairness and justice. Furthermore, it provides flexibility and adaptability of the law to new environment, and it can fulfill the true intention of Parliament. It also do not allow application of law in such a way which bring about unfair outcomes, and the purposely approved is also practical and consistent with European law because it is common among the European court to overcome literal translation issues. However, the purposely approved being in the question of judicial lawmaking and undermining parliamentary supremacy. Additionally, the purposely approved can lead to inconsistent outcomes, as different judges may have different conclusions about Parliament intention, creating uncertainty in the law. Finally, it is often difficult to infer true intention of Parliament, especially when using sources like ministerial statements. Now, I will hand over to my friend Qing Ying.
Thank you, Carol, for explaining the purposely approach. Now let's move on to the internal acts, which are two or clauses found within the statute itself that help judges interpret its meaning. There are 5 examples of internal acts, which are Act Preamble, headings and titles, definition sections, schedules and footnotes, and interpretations clauses. The preamble appears at the beginning of a statute and sets out its main purpose. It helps judges understand Parliament's intention when the wording of a section is unclear. In Attorney General and Prince Edward Augustus of Hanover 1957, the court referred to the preamble of the British Nationality Act 1948 to decide whether it applied to descendants of the Elector Sophia of Hanover. The preamble clarified that Parliament intended the Act to include such descendants, showing how it guides interpretation and resolves ambiguity. Moreover, headings and titles. Headings and titles identify the subject of sections and help judges interpret provision in context. In R. and Harris 1836, the defendant bit off another person's nose, but since the heading referred to offences involved weapons, the court ruled that biting did not fall under stabbing, cutting, or wounding. This demonstrates how headings limit and clarify meaning. Furthermore, the definition section. The definition section gives precise meaning to key terms. ensuring consistency. In Wiley and Chappell, 1868, the defendant impersonated a dead person to vote, but the phrase person entitled to vote referred only to a living person, so he was acquitted. Not only that, schedules and footnotes. Schedules and footnotes usually found at the end of statutes provide extra details and clarification. In Hurricane, Hunnam, Han and Temple, 1911, the schedule confirmed that part payment accepted as full settlement discharged a debt. Lastly, interpretation causes explain key terms for consistent application. In Davis and Goodman, 1874, the definition of carriage included all vehicles, ensuring fair application of the law. Now, let's look at the advantages of using internal acts in statutory interpretation. There are 5 advantages of internal acts, which are: clarify legislative intent, provides consistency in interpretation, supports the purposive approach, supports the accessible and immediate. Lastly, reduces misinterpretation. Internal acts help judges uncover Parliament's true intention and reduce ambiguity. Since they are found within the statute itself, they are quick and convenient to use. They promote consistency by ensuring terms have the same meaning across the act, minimize interpretation through built-in explanation, and support the policy approach by highlighting the law's overall aim. However, while internal acts are very useful, they also come with several limitations. There are 5 disadvantages of internal acts, which are: cannot cover all scenarios, potential for misleading guidance, limited scope, risk of overemphasis, and may conflict with other provisions. They only cover that what is written in the statute and may be too vague or incomplete. Over-reliance can lead to rigid interpretation, and sometimes headings or clauses may conflict with other sections, causing confusion instead of clarity. Now I'll hand over to Hui Yi, who will discuss external acts, which are materials outside the statute.
Thank you, Ching Yun. Moving on, let us talk about the external aids of statutory interpretation. So what are external aids? External aids are primarily materials outside the statute, and they are resorted to when ambiguity persists even after exhausting the internal aids. In order to find out the intent of the legislature in true sense, courts can refer to external aids. This helps judges to understand the meaning of the intention of Parliament when passing the law. There are 6 types of external aids. The first type of external aid is dictionaries and other literary resources. Courts can use standard dictionaries or legal textbooks to identify the ordinary and literal meaning of a word in a statute. This is used when the meaning of the word is not stated in the statute. Moving on, social and commercial practices can be referred to, as courts may consider the social norms and customs at the time the law was passed. This gives an insight to courts and judges as to why the law was passed. Third, courts can refer to other statutes when dealing with a case. They can use statutes with the same or similar subject matter. This ensures consistent meaning and interpretation throughout all the other statutes. Moving on, the 4th type of external aids is legislation history. Legislation history is a set of records and documents produced when the law was being passed. This allows courts and judges to refer to these records or documents to understand why the law was being passed. The 5th type of external aids are foreign case laws. Courts and judges can refer to foreign case laws when there are no past judicial precedents on a particular case. For example, courts and judges can refer to cases like Donahue and Stevenson when they are faced with a case that discusses about the neighbour principle or duty of care. Last but not least is Hansard. Hansard is a transcript of parliamentary debates in Britain and many Commonwealth countries. As per Lord Denning, to not use the Hansard would be to grope around in the dark for the meaning of an act without switching the light on. Now, I'll be discussing the case of Matla and Dawali. The facts of this case is that the plaintiff, Matla, who was a sick father that wanted to enroll his son in a private school. The private school had a rule whereby it prohibited male students from wearing a turban to school. The school refused to admit the plaintiff's son. Hence, the plaintiff claimed that the rule of the school was a racial discrimination under the Race Relation Act 1976, which was to protect ethnic groups. So the issue of this case is whether Singhs fell under the umbrella of the term ethnic in the Race Relations Act 1976. In this case, the courts referred to external aids. The courts referred to the Oxford English Dictionary to interpret the true and ordinary meaning of the word ethnic under the statute. Ethnic under the Oxford English Dictionary means a long shared history and tradition from a specific region. As a result, Singhs are an ethnic group in the Race Relations Act 1976. Therefore, the school rule and the refusal for admitting the plaintiff's son was considered racial discrimination. Now, let us talk about the advantages of using external aids. Using external aids allows courts and judges to clarify the legislative intent, as well as to resolve ambiguities in the statute. Last but not least, by using external aids, it ensures consistency when applying the law across all the other statutes. There are two disadvantages of using external aids. One of them being, external aids may reduce parliamentary supremacy. And by using external aids, it might be time-consuming, as when courts and judges have to refer to external aids, it will delay the court's judgments.
Okay, thank you Hui for explaining the external aid, and I will continue explaining one of the external aid called Hanzat. Hanzat is the official written record of proceeding in Parliament, including debates and statements made by members of Parliament. It also used as an aid to statutory interpret. The purpose of Hanzat is to keep as a public record of the decision and discussion made by Parliament. It interprets laws, especially when the meaning of an act is unclear. Hanzat only provided when the words of legislation are ambitious, and only the statement of ministers and promoters of a bill are relied upon, and the statement must be clear. And I will continue explaining the landmark case of Hanzat called Pepper and Hart. In this case, Hart and 9 others were teachers at Marvel College who benefit from a concessionary fee scheme that allowed their children to be educated at the college for 1/5 of normal fees. And then, unfortunately, there was a dispute over the correct interpretation of the Financial Act 1976. Each of these cases is whether the reference to parliamentary proceeding record to interpret the meaning of an act or statute is allowed for judge. House of Lords held that courts may refer to Hanzat when the words of the legislation are ambitious, but only the ministers and promoters of the bill of statement are relied upon, and the statement must be clear, which was the rule that I mentioned just now. Next, I will going to talk about the Dyson, Holding and Fox. This case giving the popular meaning of members of a family. In this case, plaintiffs were the freeholders or owner of a house under tenancy with defendant partners, Mr. Jack Wright. They lived as husband and wife for over 20 years, although they were unmarried. Each of these cases is whether an unmarried partner considered a member of a family under the Rent Act 1950. The Court of Appeal allowed the appeal and held that the defendant was a member of a tenant's family and was entitled to remain in the occupation. This case also reversed the earlier case of Garmat and Atkins, which excluded an unmarried partner from being a family was actually outdated. In conclusion, the rules of interpretation are not legal rules but merely approaches and adopted by judges. Its rules developed at a different stage in legal history. For the literal rule and the golden rule focus on the words used in the statute, while the mischief rule and the purposive approach focus on the intention of Parliament when passing the law. To sum up, statutes always come before a statutory interpretation. As Lord Reed pointed out, they are not rules in the ordinary sense of having some binding force. They are our servants instead of our master.
Thank you, Ellie. And these are our list of case laws and references. That is all from us. Thank you for listening.